Senator Durbin.
Thanks, Mr. Chairman, and congratulations to the nominees. The next time this committee meets, it will be to consider the nomination of Todd Blanche to be Attorney General of the United States. Mr. Blanche is President Trump's former personal lawyer, and in his role as Deputy Attorney General and Acting Attorney General, he has continued to play that role. Throughout his tenure at the Justice Department, Mr. Blanche has used the department as a shield to protect the president and his MAGA allies and a sword to attack the president's opponents. He's led the cover-up of the Epstein files. As former Attorney General Pam Bondi herself has explained, Mr. Blanche was, quote, in charge of the process and the entire release of the Epstein files. Mr. Blanche also established the $1.8 billion slush fund for January 6 cop beaters. And Mr. Blanche personally signed a document to provide the president and his family and his businesses with immunity from federal tax law violations. Immunity. Mr. Blanche has treated the Justice Department like a criminal defense firm whose sole client is Donald Trump. And he has abused the awesome prosecutorial power of our nation's top law enforcement agency to target anyone who dares to cross the president. This includes baseless and vindictive investigations or indictments of members of the Federal Reserve, former FBI Director James Comey, and the Southern Poverty Law Center, to name a few. The President and Mr. Blanche's efforts to fill the department with loyalists extend far beyond Washington. They have repeatedly bypassed this committee to illegally appoint U.S. attorneys whose resumes prove their devotion to the MAGA movement rather than any experience or integrity. This leads me to the subject of blue slips. Last week, Chairman Grassley stated that as long as he is chairman, this committee will continue to require blue slips from home state senators before considering district judges and U.S. attorney nominations. I am thankful that Chairman Grassley shares my commitment to preserving the blue slip, but the chairman inaccurately accused Democrats of obstruction for refusing to return blue slips for some nominees. Now the rest of the story. For the past 18 months, the committee has considered nominees to fill dozens of judicial vacancies in red states that Republican senators held open for years by refusing to return blue slips during the previous administration. Many Senate Republicans, though not all, engaged in unprecedented obstruction despite good faith efforts by the Biden White House to fill vacancies. Consider this. During the Trump administration, the first Trump administration, Senate Democrats returned 130 blue slips for Trump district court nominees. This led to the confirmation of 84 of these nominees, almost half of all the Trump district court judges in his first term. However, during the Biden administration, Senate Republicans returned only 54 blue slips, 130 for Democrats, 54 for Republicans, leading to the confirmation of 32 district court judges, less than 30% of all Biden district court judges. While I encourage Senate Democrats to work in good faith with this administration to fill vacancies in their state, it needs to be a two-way street. This administration's approach frequently involves the president or White House announcing nominees as a take-it-or-leave-it proposition with zero prior consultation with home state senators. The Trump administration has tried to install nominees in U.S. Attorney's Office in states like New York, New Jersey, and Virginia, with no attempt to consult the Democratic senators representing those states. Many of these individuals have been disqualified from serving as U.S. attorneys after courts found their appointments were unlawful. And many are simply unqualified to serve as U.S. attorneys, including individuals with zero criminal experience and whose principal qualification is political. Blue slips are an important part of the Senate's constitutional duty of advise and consent, and in the face of lawless administration, they help senators defend the integrity of U.S. attorneys' offices and the independence of our judiciary.
What you just heard is not a floor speech. It is not a press release. It is a formal statement entered into the official record of the Senate Judiciary Committee, delivered by Senator Dick Durbin of Illinois, the longest-serving Democrat on that committee, in direct anticipation of a confirmation hearing for the man he named by name, Todd Blanche, nominated to be Attorney General of the United States. Understand what that means before anything else. The Attorney General is not a cabinet position like others. The Attorney General runs the Department of Justice. Every federal prosecution in the United States flows through that office. Every decision about who gets investigated, who gets indicted, who gets immunity, and who gets left alone, those decisions live in that building. And Durbin used his time at that committee table to put something very specific into the record about the man being asked to run it. Let's examine what he actually said, and let's examine it the way the record demands, precisely in sequence, with both sides given their full weight. Durbin opened with a description. Todd Blanche, he said, is President Trump's former personal lawyer. That is a documented fact. Blanche represented Donald Trump in multiple criminal proceedings before his appointment to the Justice Department. Durbin then said that in his role as Deputy Attorney General and Acting Attorney General, Blanche has continued to play that role, meaning continued to function as Trump's personal attorney rather than as an independent law enforcement official. That is not a fact. That is a characterization. And it is the characterization that everything else in Durbin's statement is designed to support. The first piece of evidence Durbin offered was the Epstein files. He said Blanche led the cover-up of those files. He then immediately cited a source, not a Democratic critic, not an opposition researcher, but former Attorney General Pam Bondi herself, a Trump appointee, who stated that Blanche was in charge of the process and the entire release of the Epstein files. Durbin's use of that attribution was deliberate. He was not asking the committee to take his word for it. He was citing the previous occupant of the office Blanche now seeks. The second charge was a $1.8 billion fund, what Durbin called a slush fund for January 6th cop beaters. That language is Durbin's characterization of a fund established to compensate individuals convicted in connection with the January 6th Capitol breach. The amount, $1.8 billion, is a documented figure. The characterization of what it represents is contested. Durbin's framing is the most aggressive possible reading of what that fund is and who it benefits. The third charge is the one that carries the most institutional weight. Durbin said Blanche personally signed a document providing the president, his family, and his businesses with immunity from federal tax law violations. If accurate, and Durbin stated it as fact, that is not a policy disagreement. That is a specific legal act taken by a senior law enforcement official to shield the person who appointed him from criminal or civil tax liability. Durbin did not hedge that claim. He put it into the record directly. He then described what he called baseless and vindictive investigations or indictments, naming the Federal Reserve, former FBI Director James Comey, and the Southern Poverty Law Center as targets. Each of those is a real institution or individual. Each has been publicly reported as a subject of Justice Department scrutiny under the current administration. Whether those investigations are legitimate law enforcement activity or politically motivated prosecutions is precisely the question Durbin is asking this committee to weigh when it votes on Blanche's confirmation. Then Durbin shifted. He moved away from Blanche specifically and toward a structural argument about how this administration has approached the judiciary more broadly. And this is where the statement becomes something more than an attack on a single nominee. It becomes a case about institutional architecture. He raised the blue slip process. For viewers unfamiliar with this mechanism, a blue slip is a procedural tool in the Senate Judiciary Committee. When the president nominates a federal district judge or U.S. attorney, the two home state senators are sent a blue slip, a formal notice requesting their consent. If a senator does not return that slip, the committee traditionally does not advance the nomination. It is one of the Senate's primary tools for ensuring that home state senators have input into who serves in the federal judiciary within their states. Durbin presented a specific numerical comparison. During Trump's first term, Senate Democrats returned 130 blue slips for Trump district court nominees. That led to the confirmation of 84 of those nominees, nearly half of all Trump district court judges in that term. During the Biden administration, Senate Republicans returned only 54 blue slips, resulting in 32 confirmed district court judges, less than 30% of all Biden district court judges. Those numbers are in the record. The asymmetry they describe is in the record. Durbin's argument from those numbers is that Republican senators engaged in what he called unprecedented obstruction during the Biden years, while Democrats cooperated in good faith during Trump's first term. He is making a reciprocity argument that the current Democratic resistance to blue slips is a response to what was done to Biden's nominees, not a departure from established norms. Chairman Grassley had accused Democrats of obstruction for refusing to return blue slips on some current nominees. Durbin's response was to put the comparative numbers on the record and let them stand alongside Grassley's accusation. He then described what he said was the administration's approach to U.S. attorney nominations, announcing nominees without prior consultation with home state senators, particularly in states like New York, New Jersey, and Virginia, where Democratic senators represent the state. He noted that courts have found some of those appointments to be unlawful, and he raised the question of qualification, noting that some nominees have zero criminal law experience and whose principal qualification, in his words, is political. Now, two things can be true at the same time. The blue slip process has historically been applied inconsistently by both parties depending on which party held the White House. The numbers Durbin cited are real, but the context around them is disputed. Republican senators during the Biden years argued they were responding to specific nominee choices, not engaging in blanket obstruction. A defender of the current administration would argue that the president has the constitutional authority to appoint law enforcement officials who share his priorities, and that framing those appointments as politically motivated is itself a political characterization. On Blanche specifically, a nominee who previously represented the president as a private attorney is not automatically disqualified from serving as attorney general. The question of whether prior legal representation constitutes a conflict of interest that cannot be waived is a legitimate legal debate, not a settled one. And the argument that Blanche has used the Justice Department as a shield for Trump rests on a series of characterizations, some of which Durbin documented and some of which he asserted without citing specific evidence in this statement. Both of those are reasonable positions. What Durbin was building, however, was not a legal brief about any single charge. It was a cumulative record. The Epstein files, the $1.8 billion fund, the immunity document, the named investigations, the blue slip numbers, the court findings on unlawful appointments, each item placed in sequence, each one attributed or documented, building toward a single structural conclusion that the Justice Department under Todd Blanche has ceased to function as an independent law enforcement agency and has become, in Durbin's precise language, a criminal defense firm whose sole client is Donald Trump. That sentence is now in the official record of the Senate Judiciary Committee. It will be there when this confirmation is voted on. It will be there when these investigations are examined. It will be there if any of the named targets, Comey, the Federal Reserve, the Southern Poverty Law Center, bring legal challenges to the conduct of those investigations. The most overlooked part of Durbin's statement is what he did not do. He did not call for a delay. He did not move to block the hearing. He did not threaten procedural obstruction. He entered the record, he named the numbers, he cited the source, Bondi's own words about Blanche's role in the Epstein file release, and he yielded. So here is where this exchange leaves us, and it is genuinely two-sided. Was Senator Durbin conducting legitimate pre-confirmation oversight, documenting a pattern of conduct that raises serious questions about whether a former personal attorney can independently run the nation's top law enforcement agency? Or was he delivering a political indictment dressed as institutional concern? Was Todd Blanche exercising lawful prosecutorial discretion on behalf of an administration whose priorities differ from the previous one? Or was he something the framers of the Justice Department never anticipated, a personal lawyer who brought his client relationship with him into the building? Two different stories. Same committee, same official record. Tell me in the comments which version you walked away believing. If you stayed this long, subscribe. The confirmation hearing has not happened yet.